the chapter does play a role. There is a Supreme Court holding that says that there's nothing you can do in a Chapter 7. I'm talking about personal bankruptcy here. Business bankruptcy is a different world. So if, for example, you have a consensual lien against your principal residence, whether it is wholly unsecured, partially unsecured, or wholly secured, there's nothing you can do about that in a Chapter 7. However, in a Chapter 13 or a Chapter 11, there is something you can do if it's wholly unsecured. Now, what do I mean by wholly unsecured? Well, we don't see this these days a whole lot because real estate prices have been going up and up and up, but, well, probably the law of gravity will affect real estate prices eventually, and that'll change. But some years ago, we did see this where the value of the property in question is less than the current balance on the first mortgage. Well, what does that say about the second mortgage? There's no house behind it. If I can use hand gestures, here we have the first mortgage balance, the value of the property. We've got the second mortgage here. There's no house behind it. So in that special situation, in a Chapter 11 or Chapter 13, you can strip that second mortgage off because it's wholly unsecured and treat it as an unsecured debt in your repayment plan, which means you might not have to pay it off at a very high percentage. And then as long as you complete the plan, that debt is extinguished. So you have shaved off an entire second mortgage and made payments perhaps on pennies on the dollar. Well, that you can do in either a Chapter 13 or a Chapter 11. Now, in a normal Chapter 13 or a normal Chapter 11, if you have a partially secured lien, there's nothing you can do if it is secured solely by your principal residence. If it's secured by something else, that's a different story. But the Bankruptcy Code has provisions in both Chapter 11 and Chapter 13 that say, sorry, if a secured debt is secured solely by your principal residence, you cannot modify that debt. Having said that, a while ago, maybe about a year and a half now, Congress enacted and the President signed into law is something called Subchapter 5, the Small Business Reorganization Act, which became Subchapter 5 of Chapter 11. Now, you have to be able to qualify to use this, and there's a debt ceiling there, and there are some additional requirements that you have to satisfy. But if you do satisfy that, and you can be a small business debtor under Subchapter 5 of Chapter 11, then you can bifurcate a partially unsecured, partially secured, partially unsecured debt that is against your principal residence. However, the debt cannot have been incurred primarily to purchase the property, and it must have been incurred for the business that you're running, because after all, you're supposed to be a small business debtor. So in that situation, if you have a partially unsecured mortgage against the property, you can bifurcate it into a secured portion and an unsecured portion. And then that unsecured portion you can pay as if it were, let's say, credit card debt or some other general unsecured debt, so you wouldn't necessarily have to pay that in full. The secured portion, of course, you still would have to pay that in full. But the unsecured portion you could treat as just general unsecured debt. So that can really be quite powerful, provided you can satisfy the requirements of getting into Subchapter 5. Now, as far as a wholly secured debt, no, unless the creditor accepts adverse treatment, that's there to stay. And if it's oversecured, that creditor even gets interest, post-petition interest on payments through the plan.